Hi, my name is David Lundgren. I'm an attorney at Lundgren & Johnson. Our practice area is exclusively criminal defense, and a large portion of that criminal defense practice are DWIs. One of the most important things to keep in mind after you've been arrested for DWI is your license will be revoked after a 7-day time period following the offense. You'll have a 7-day temporary permit to drive for the 7 days following your arrest, but after that you will not be able to drive. And in conjunction with that, you only have 60 days in order to challenge that license revocation, meaning if you don't file a challenge either administratively or through a judicial review within 60 days, that license revocation will be permanent. It will always be on your record for the remainder of your lifetime, and you'll have to serve the entirety of that license revocation, even if you walk into a criminal courtroom on the criminal charges and walk away with a complete dismissal. And that's because even though they're related to the same incident, there's two separate things that get triggered once you're arrested for DWI. The first is the civil license revocation portion, and you'll receive notice of that. And the second are the criminal charges that result from that offense. If you were arrested for DWI, you likely completed some field sobriety tests before you were arrested. Some things to keep in mind about those field sobriety tests are that they are standardized tests, meaning that they have to be administered in a standardized manner. And in fact, there's a whole DWI field sobriety test manual that law enforcement officers are trained on. And if you can't tell, the manual is fairly thick. It is very detailed about the steps that have to be taken by the officer and how the tests are administered. And because they're standardized tests, if the officer did not complete those tests in the standardized manner, the conclusions to be drawn from those tests are not sound, meaning the officer's conclusion that you were impaired or likely impaired because of your performance on those field sobriety tests can be invalid if he or she administered the tests incorrectly. A good DWI lawyer will know those field sobriety tests backward and forward, how they need to be completed by the officer, how they need to be administered by the officer, what the officer should be looking for as far as your performance on those tests, so that if your case proceeds to trial, those tests and the administration of those tests by the officer can be challenged in a meaningful way. If you'd like to learn more about field sobriety testing, the administration, the tests in general, we have an article on our website. I'll put the link in the description below. It's important to know that the test that you took, if it was a data master breath test, the results from that aren't necessarily what they appear, meaning what you get after you complete the breath test is a printed out graph. It'll have two different graphs on there with your blood alcohol concentration curve as measured by the data master machine. What's important to note is that the numerical value, the final value of the data master test, is only the machine's best guess at what your blood alcohol concentration is at that point in time. There's an uncertainty of measurement that is built within the machine, meaning that the number that's given is just the median value of the machine's best guess. There's actually a range on the lower end and the higher end where your blood alcohol concentration could be. And there's a mathematical formula to tell you the percentages of how likely it is that your blood alcohol concentration was actually lower than that amount, and if your blood alcohol concentration, the percentage that it was actually higher than that amount. Fifth, any charge that is relying upon your blood alcohol concentration, either from a blood, breath, or urine test, The statute requires that the state prove your blood alcohol concentration either at the time you were driving or within 2 hours after the time you were driving. For most cases, it's the latter, meaning 2 hours after the time you were driving, because they have your either blood, breath, or urine test that was taken within that period of time. But there are a handful of cases, and not an insignificant amount of cases, where that blood, breath, or urine sample is not taken within that 2-hour time frame after the time you were driving. In those cases, the state is required to prove and show some evidence about what your blood alcohol concentration was within that 2-hour time period. How this is normally done is through what's called a retrograde extrapolation of your blood alcohol concentration. And they do that by providing whatever police reports and documents that they have about the testing process to the Minnesota Bureau of Criminal Apprehension. Once it gets to the Minnesota Bureau of Criminal Apprehension, a forensic scientist will look over all of those reports and plug in some variables into a mathematical formula which estimates what your blood alcohol concentration actually was within that 2-hour time frame. Now that science, that mathematical formula that's conducted, requires a set of known variables in order to complete it, and oftentimes those variables are not known to the state, but that doesn't stop the BCA scientist from still going forward and making that calculation. In those circumstances, that calculation is subject to a pre-trial attack on the reliability and admissibility of that retrograde extrapolation based on its unreliability. If you're interested in learning more about retrograde extrapolations and the different issues that can come up in a DWI case and trial when the state's evidence relies upon a retrograde extrapolation, we have an article that details all of those issues fully. I put a link in the description below. If you're facing DWI charges, you owe it to yourself to learn as much about that offense as possible so that you can be prepared to assist your lawyer in defending you against those charges. We've spent quite a bit of time creating articles and writing articles and putting them on our website just about that topic. I put a link in the description below to our main DWI page, which at the bottom has links to all of the different topics we've written about DWI. Now, this is not meant to be legal advice. It's meant to be reference information for you so that you can learn a bit about DWI offenses and the different defenses that apply. If you've been arrested for DWI, consider giving me a phone call to discuss your circumstances. Over the last 8 years, I've obtained positive outcomes for my clients in DWI cases. I've received awards and recognitions for my DWI service. We can talk about the civil consequences to your DWI charge, the civil license revocation, as well as a potential plate impoundment, potential motor vehicle forfeiture. We can also discuss the criminal charges and a roadmap moving forward to get you back on the road and to start putting a successful defense together. I put a link in the description below to our website. Our contact information is also there, including our phone number. I look forward to speaking with you shortly.